because these are criminal charges, you do have certain rights. You have the right to have an attorney represent you. Even if you cannot afford one, one will be appointed by the court if you ask. You have the right to remain silent. Everything you say is being recorded and can be used against you. Was everybody sworn?
Yeah, I've been there.
All right. State, please announce your presence.
James Stewart for the state.
I do have a member of the Public Defender's Office. Please announce your presence. Good afternoon. All right. I've got Dustin Robert Cantor first. 21 MM365.
Yes, sir.
Good afternoon, sir. All right, sir, you're here for a charge of battery. This is a domestic violence case. Would you like to have the public defender appointed at this time? You would not. All right, are you going to be representing yourself today? That's fine. Would you like to have the assistance of the public defender today? All right, very well. All right, I've reviewed the probable cause affidavit. I do find probable cause. State, do you have any information to provide to the court at this time?
Judge, from looking at his criminal history, I see a conviction for possessing a prescription drug without a prescription, a possession of paraphernalia conviction, a conviction for possession of liquor by a person under 21, and then there's a little bit of a juvenile history and an out-of-state arrest.
All right. All right. So your bond, you said at $2,000, or you do qualify for pretrial release. So what that means is you don't have to put up any money in order to get out of jail today. All right. But either way, you have the following conditions of release. You may not have any contact with the alleged victim, sir. You may not return to the address that you share in common with the alleged victim, except for one time to retrieve personal items. And if you're going to do that, you have to do it with the company of a law enforcement officer. That's for your protection as much as it is for hers, okay? You may not possess any firearms while this case is pending. And if you have any, they must be turned over to the sheriff's office within 24 hours of your release. Now, if you sign up for pretrial release, once again, that means you don't have to pay any money to get out, but you will have the additional condition of random drug screens. There'll be a GPS monitor installed. You must stay at least 500 feet away from the alleged victim, and you'll have to check in with pretrial services, okay? All right, good luck to you, sir. Take care. Francisco.
Yes.
Good afternoon, sir. Sir, you're also here for a charge of battery. Did you want to have the public defender appointed at this time? All right. I've reviewed the probable cause affidavit. I do find probable cause. State, this is a domestic violence case. There's information provided to the court at this time.
Your Honor, the only thing I could find for him was a no valid driver's license from 2008.
All right. Bond in this case will be set at $2,000 or pretrial release. I think you heard me say to the other gentleman that means you don't have to put up any money in order to get out of jail. But either way, as conditions of release, you may not have any contact with the alleged victim. You may not return to the address where this is alleged to have occurred except for one time to retrieve any personal items, and that must be with the company of a law enforcement officer. Once again, that's for your protection as much as it is for hers. You may not possess any firearms while this case is pending, and if you have any, it must be turned over to the sheriff's office within 24 hours of your release. If you do sign up for pretrial services, you will have the additional conditions of a GPS monitor, and you'll have to check in with pretrial services by phone, okay? All right, good luck to you. Thank you. Courtney Gonzalez. All right. They indicate whether or not they wish to have the public defender appointed. All right. They're here for alleged violations of state probation. I'm going to proceed in their absence. I review the probable cause affidavit. I do find probable cause. Bond said no bond alternates. John Joe Guajardo. Yes, sir. I'm glad you're here, Mr. Clark. Give me just a moment. All right, Mr. Guajardo. Actually, Mr. Clark, go ahead and announce your presence.
That's Ian Clark, Mr. Guajardo.
Hold on. So, Mr. Guajardo, what I have before me, and Mr. Clark, maybe you can help clarify this for me, because I have some questions. Is a contempt of court charge / DWS out of Henry County. I found a case number in the NCIC that I cannot find on the Henry County Court's website.
I wasn't able to find it either.
So I don't understand why Mr. Guajardo is here. Mr. Stewart, do you have any information you can share with us? Because I'm.
Judge, I spoke with Ms. Cunningham yesterday, and actually, Ms. Guajardo was in front of Judge Foster resolving him this case yesterday. They didn't do that without application. They did take him into custody on this. Apparently, in Hendry County, this is what Ms. Cunningham explained to me, is that if you don't pay your court costs on a case, so essentially he's completed the case, he's completed his probation, he's done everything he was supposed to do, but he didn't pay his court costs. So what they did was they set a hearing to answer that. So Ms. Guajardo missed that hearing, so the potential went out to
Really?
Had a bondsman. Tried to pay this bond yesterday, but unfortunately they said they wanted up for judge. So that's why we're here today. I didn't see a case, but Mr. Guajardo doesn't inform me that there was a case. Tried looking it up via his name, his date of birth, his case number. None of those things actually came up in any. So here we are. They indicated that they would transport and fully expedite according to the warrant. But that's why we were trying to bond them out here so we can get out here and then go issue up there.
Okay. Mr. Stewart?
Judge, I was able to find his case in the statewide clerk system, and I think everything Mr. Clark just said is accurate. I think the case was resolved long ago. I do see some docket entry sometime in April from the clerk's office to him called notice of failure to comply, letting him know if he doesn't contact their office before a certain date, that there will be an issuance of a warrant. So I mean, I think it's related to this case, as I can see. It looks like they've set a bond. I don't know what else we can do.
Mr. Guajardo indicates that he never received that notice. I don't know if his address has changed since. After a case, I don't know if he's responsible for keeping his treated in this county. They would have sent this to election. We're not county.
I presume the warrant was issued by
Judge Hill.
In Hendry County?
Yes.
Okay.
I mean, he's happy to bond out, and that's what he's trying to do.
Is he able to post the bond? It's $1,053. Mr. Guajardo, can you post that bond?
We're through a bail bond.
That's fine. It's cash for surety. He can post that bond.
Yeah, we have somebody lined up.
All right. Well, there was a warrant issued by a judge for this. Bond was set at $1,053.
And I appreciate you looking at it. Honestly,
I will express my thoughts about this to the chief judge later.
I'd appreciate it, but for the purposes of now, he needs to get out and get back to work.
He can post this bond now, as long as he can post it, fine. And I will have a chat with the chief judge.
Guajardo, I'm going to contact your bail bondsman now and let you know that you're bondable. So should be getting out this evening.
Okay.
Thank you
sir.
so much, Judge. I appreciate you taking it.
Yes, sir. All right. Philip Armin Imbert. Good afternoon, sir. Sir, this is 21MM366 and 21CF330. You're here for a charge of resisting an officer without violence and for a warrant, a habeas warrant for a charge of battery on a person 65 years of age or older. Would you like to have the public defender assigned at this time? Would you like me to appoint a public defender for you, sir? All right, I'm going to appoint a public defender at this time. I reviewed the probable cause affidavit. I do find probable cause on both cases. Does the battery charge qualify as a domestic violence case?
I believe so, Judge. At least it was booking paperwork was stamped domestic violence.
Then in that case, State, you have information you need to provide for this time?
Yes, Judge. So in terms of criminal history, I see a 2012 possession of paraphernalia, 2012 possession of a controlled substance, possession of paraphernalia, possession of marijuana from 2010, and I believe that covers it because I don't believe there was an out-of-state history, so that's the extent of it.
All right. Do you have a specific request for bond amounts or conditions of release?
I don't have any specific requests now.
Bond on the resisting charge is $5,000. Yes? It is. I understand, but I consider him to be a flight risk since he ran away from the officers trying to serve him with a warrant. Right. That's the reason for the heightened bond. On the 21 CF330 battery, bond is also set at $5,000. Sir, you may not have any contact with the alleged victim. You may not return to the address where this is alleged to have occurred. You may not possess any firearms while this case is pending. If you have any firearms, they must be turned over to the sheriff's office within 24 hours of your release. Good luck to you, sir. Charlie Prey. All right. Good afternoon, Mr. Prey. You're here for a charge of loitering or prowling. Would you like to have the public defender appointed at this time? I'm going to appoint the public defender. This is 21MM364. Ms. Woodley, you have PCR. Okay. Yes, please. Well, let me, yeah, come on up, but let me ask the state real quick. Are you arguing that there is probable cause state?
Yes, Judge, I am going to make that argument.
Okay, and this one, you're going to save the time if they argued otherwise, or we're taking a different position. All right, go ahead with your argument.
So under the plan that pretty much the same argument that I always make every time I make this argument, but for the record, there was no imminent threat. That's what seeing someone who has a similar sweater is not enough. This was a mere hunch. This was not imminent threat to personal property.
All right, Dave?
Your Honor, I could not hear some of that, but I'm just going to make my argument and let it be. In order to prove a loitering and prowling, of course, we're at the probable cause stage, but there needs to be evidence that Mr. Prey was loitering under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. And I think to assess that, I think the intelligence that the sheriff's office had is important, because he matches the description of someone involved in multiple recent burglaries throughout the county, observed on surveillance footage, and he is wearing a fairly distinctive sweatshirt on this night at 1 a.m. that he was wearing in those burglaries, according to the sheriff's office. He takes flight upon sight of related to the prior burglary allegations, and if the court looks at the statute 856.021, subsection 2 does state among these circumstances which may be considered in determining whether such alarm or immediate concern is warranted is the fact that the person takes flight upon appearance of a law enforcement officer, refuses to identify himself or herself, which of course goes in hand with the fact that he ran away and led them on a chase through Immokalee. I think they also mention at a certain point that he was back between houses, continuing not to stop upon seeing law enforcement. So I think that, and also wearing a hood at 1 a.m. As he's walking through Immokalee. So I think when you combine the intelligence law enforcement has, and they back it up with the identification of him wearing, I think, a fairly distinctive item of clothing, I think for probable cause purposes, that's satisfactory for loitering and prowling.
No. The problem is, at the time they saw him, he was just walking, wearing clothing that otherwise matched the description of burglary.
Well, Judge, they didn't stop him.
Right. There may have been a better charge that they could have brought under the circumstances when he took flight from them, because they may have had sufficient reasonable suspicion to stop him and conduct a criminal investigation, but that's not what they charged him with. So I find no PC. Sir, you'll be released on this charge, and it does not mean that the charge goes away. Clearly, the state attorney's office disagrees with my assessment of this, which means that they can absolutely still charge you with this. So you do have a court appearance March 25th for arraignment, and if the state is pursuing this charge, you are going to be required to be there, okay? And then, of course, if there's other charges coming, they will come shortly. All right. Good luck to you, sir. Yes. All right. Good luck, sir. All right. Matthew Reyna. All right. This is 21 CF 333. Sir, you're here for a charge of driving on a suspended license as a habitual traffic offender. Would you like to have the public defender appointed at this time? All right. I reviewed the probable cause affidavit. I do find probable cause. Bond is set at $5,000. Good luck to you, sir. Victoria Ann Elkin. Oh, we have to switch over. Yes? Oh, hold on. Was I right or wrong? Is Victoria Elkins in that room, or is any other room? If I say that, it's perfect. Yeah, you're fine. Unless Tommy has a problem. Tommy can make you stand over there. Tommy's taller. Do you have anything else? I cut you off. No, that's it for the third quarter. Thank you. you hear us?
Hello, can you hear me?
All right. All right, folks, you're here for first appearance. At first appearance, I'm going to inform you of the charge and charges pending against you. I will then determine whether or not there's probable cause for those charges. If I do find probable cause, we'll discuss what conditions, if any, are appropriate for your release. If I do not find probable cause, you'll be released in your own recognizance. Because these are criminal charges, you do have certain rights. Amongst those rights is the right to have an attorney represent you, even if you cannot afford a lawyer, but will still be appointed if you ask. You have the right to remain silent. Everything you say can and will be used against you and is being recorded. First case I have is Victoria Ann Elkins, 21 MM318. Is everyone sworn in this room? All right.
Good afternoon, Judge Derek Morello on behalf of Ms. Elkins. Judge, with regard to an outspoken Mr. Stewart all week about this case, the issue of trespass charge, we dispute the factual allegations set forth. We don't have the right to respect the trespass mindset. We do have evidence that may or may not disprove the reason. I know she's out on bond investigation.
All right. I reviewed the probable cause affidavit. I do find probable cause. I think, as conditions of release on this case, ma'am, you may not return to Monterey Point in the Marbella Lakes community, and you may not possess any firearms. Now, let's talk about bond in this case, as well as the impending state's motion to revoke bond.
And part of my issue with not revoking the bond is I'm going to ask you to add additional conditions to the trespass bond as well.
All right. I gotta be honest with you, Mr. Burrell. I find the underlying allegations and what's going on here to be tremendously concerning for the safety of the folks who live in that
I
community.
don't disagree with you, and I can tell you, and I know this, that I've litigated this exact issue with Mr. Stewart and Your Honor on another case and case law.
Okay.
Restricted means. And I do have a suggestion for the court to alleviate any concern.
I'm listening.
There is a case law out of the Second District recently in March 2020, and I'll use the language that it says the court is. It requires the court to impose the first least restrictive listed conditions that will reasonably protect the community from risk or harm to persons, assure the presence of the accused at trial, and assure the integrity of the judicial process. If no single condition would adequately satisfy those criteria, the court is permitted to impose a combination of conditions. The reason why I point that out is I've spoken to my client. She's a homeowner in the community. She's willing to give up her right to go back to her home and be trespassing the entire community. It's a man-gated community, 24 hours. She's willing to relinquish her clicker, her scapegoat access card, whatever it is, as well as being trespassed from the entire community. That would alleviate any concern. The prior cases she got on bond with, as well as this case, all stem from this issues with the community. There's also a civil case pending right now as well. But everything stems from the disagreements and disputes within the community. Well, the least restrictive means was me to remove her from the entire community. Additionally, I've spoken to Ms. Elkins, a GPS. I know that you've ordered that previously. A GPS would also ensure. So one should be monitored and two should be prohibited from the entire community. And I believe that would alleviate some of the concerns. The allegation took place back on January 13th, 40 days. She retained me shortly after. There's been no other allegations. The allegations that are set forth in the trespass, we have cell phone footage that Mr. Stewart provided to me, so 55 seconds. I have it here for let's see it. But the allegation is that she walked onto the property. There was no violence. There was no direct verbal communication to the headies, the individuals. And that's something the court should consider. It was a situation where she presented herself at a street that she's allowed to be on. She's allowed to be on Marbella Drive. That's where the video kicks in. She's allowed to be on Marbella Drive. Monterey Point comes to us, and I have an aerial photo if you'd like to see it.
So Monterey Point is not the same subsection of this community.
It's all in the same subsection. What I can do is show you that I'll mark 2 X's, and Mr. Stewart's familiar with this. There's 2 marks. My client's home is right here.
Okay.
The entrance is here.
Okay.
This is where the alleged trespass took place. This is Monterey Point. This is the street right here. So the street. It's
Oh,
contained in the computer. It's not a
separate-
subdivision, no.
It's just that street.
And in order for my client to egress and ingress into the property, into her home, she has to go through the man-guarded gate at this location here and drive through and to get to her home here.
Okay.
But what I'm suggesting to the court is that she is being prohibited from doing the complex completely, and she's willing to find an alternative place in lieu of being sitting in jail. On the aggravated assault charge, Judge, I can tell you that the state, and I've spoken to Mr. Ashby in that case, but that's my the state's offer is to withhold adjudication, probation, no incarceration, and obviously no contact, trespass provisions, and things like that. But in terms of less restrictive and what we could do to ensure to protect the citizen or the community itself, get her out of the community and ensure that she's not going to go back to the community. And if she goes back to the community, she understands her profession, that she'll be locked up and she'll be monitored 24/7.
Mr. Stewart? Oh, sorry, I thought you were done.
No, but that's it. I'm not going to get into the strengths and weaknesses of the case. We feel that we have a strong argument with the trespass case. I'll say that for a later date. In terms of whether there's surveillance footage from the individuals that live in the, we know there's surveillance footage, but unfortunately it didn't capture the alleged event. We do have cell phone footage, but the cell phone footage shows that she's in the spot where she's regularly on the case, and she would not be trespassed.
All right. Mr. Stewart?
Well, Judge, obviously, I'm going to ask the court to revoke her bond. It's not just that she was arrested for a new law offense. She's arrested for being on the property of the victim from the pending offense. So that, to me, that makes it more concerning. And I understand that the video that we do have and did disclose does not show the literal trespass. It's certainly evidence that she was in the area at the time, but the sworn statement from the victim or the witness states that she was on her property prior to the cell phone video beginning. And in terms of additional conditions of bond, this no trespass on Monterey Point in Marbella Lakes was a condition of her bond in the aggravated assault case. So she was already ordered to not do something. She didn't obey. So I have no reason to believe that she's going to obey this court's order. So for those reasons, I would ask the court to revoke bond.
Very brief rebuttal, Judge. Two different people. The underlying case deals with the Gonzalez's, the headings. They're two different people, so they're not. It's different. It's a house further up the road. And I think the difference with the suggestion that I'm making to the court in compliance with the case law is that there is some confusion, as I showed you on with the map. She has to drive down the street to get into the home. And that's the difference, is that she drove on that street that she's allowed to be on, which is Marabella Drive. She lives her address in her. She has to drive by that location, Monterey Point, to get to and from the home. I think the distinguishing factor in the concession that Ms. Elkins is willing to give up is that she will never go back to that location while it's the entire community. So there's no ambiguity. There's no reason for her to be in the neighborhood. There was a reason before because she was allowed to be there. She just had to be restricted off of Monterey Point, which is the T intersection. And that's the dispute of where we come into it. The cell phone footage that has been provided, she's standing on Marabella Lakes, which is where she's allowed to be. There's a big distinguishing factor of limiting her ability to even go in the community where it's a guard-gated facility. And again, would protect, the least restrictive means would protect the community from Ms. Elkins and direct contact and/or communication. And again, I'll point out, there was no violent communication. There was no even verbal communication on the evidence that's been provided by Mr. Stewart. It's literally a separate party, not the party from the first case, saying, you're not allowed to be in this location. Technically, where she was standing, she was allowed to be. But that's what they're saying. Ms. Elkins says nothing in response, puts her head down, gets into her car and leaves. And that's the allegation for the trust.
And Judge, I just add the people involved in this new trespass are involved in the aggravated assault case. They're witnesses.
I know. I understand. And there is a temporary injunction in the civil case that was issued by Judge Martin specifically protecting those folks as well.
Okay, that's a separate issue, Judge. That's not the trespass. We're dealing with a trespass at this point, and there was nothing.
No, they all go together.
Well, it's a no contact, so I mean, we can intertwine them, but she's here on a trespass, but that's
I
the
understand.
difference, is that she will not, she's standing where she's allowed to be, she's not violating Judge Martin's order.
Well, she's standing where she's allowed to be, then there is no trespass.
No, on the video. And that's the dispute, because the Heddies are saying she walked down the sidewalk, my client saying she didn't walk down the sidewalk. And what may or may not disprove her innocence is that the Heddies have Nest camera footage. We know that. Miss Elkins knew there was camera footage. Miss Elkins knew that if she went on that location, she'd be captured on Nest camera footage from the side of the home. That's exactly. Ironically, the state is not able to provide me with the Nest camera footage. It didn't capture that day. It's worked before and it's worked after, but it didn't work on January 13th. We don't know why.
Here's the problem. We are really kind of digging down deep and litigating
I understand.
the issues here.
Correct. The case law.
And the problem is this: what I've got is not just a probable cause affidavit, but the state attorney has reviewed the allegations and decided to pursue charges nonetheless, and it did issue a capias under the circumstances. And the allegation is that there was a trespass on the property of one of the folks who was a witness to the original case, where there was specifically a no trespass order issued by Judge Martin. There is a second injunction issued under the CC case issued by Judge Martin for the same people in the same location. And then subsequent to that, this is alleged to have occurred on the 13th. The
Order was signed on the 13th.
The order was signed on the 13th. Bond in this case on the trespass is $10,000, and the state's motion to revoke bond is granted.
Thank you, Judge.
Thank you. Good luck to you, man. All right. Cassandra Richmond. This is 21 CF 332. Good afternoon, ma'am. Ma'am, you're here for a charge of possession of controlled substance, specifically fentanyl, possession of marijuana less than 20 grams, and possession of paraphernalia. Did you wish to have the public defender appointed at this time?
Yes.
I'm going to appoint the public defender. I've reviewed the probable cause affidavit. I do find probable cause on the counts. Bonds will be set as follows. On count 1, 5,000, count 2, 2,000, count 3, 2,000, or pretrial release. And so, ma'am, you don't have to put up any money in order to get out of jail today. But if you do sign up for pretrial release, you have to abide by the following conditions. You are subject to random drug screens, and you'll have to check in with pretrial services as directed, okay?
Yes, sir.
All right, good luck to you. Terrell Harris. This is 20 CF 168. Good afternoon, sir. Sir, you're here for an alleged violation of state probation, with the original charge being grand theft. There's a warrant issued by Judge Foster alleging a violation of Condition 5, that you failed to live and remain without violating any law by committing the new criminal offense of grand theft on February 12th of this year. Would you like to have the public defender appointed to assist you, sir? I'll appoint public defender at this time. Having reviewed the warrant, I do find probable cause. Judge Foster has ordered that you be held without bond, sir, so accordingly, bond will be set at no bond. And I wish you the best of luck, okay? Take care. Roger Lee Roush.
Roger, you have to wait 1 second before you.
Oh, okay. Yes.
And Mr. Roush and Mr. Hall are being transported to Pinellas County tomorrow.
Ah, well, that helps me out, because I was going to have a discussion about that, so let's do this. Roger Lee Roush and Robert Hall, I'm going to reset them both for 24's tomorrow, if not transported to Hillsborough County, Pinellas County, excuse me.
Well, they are for sure going tomorrow, but we can't let them tell them.
I'm sorry?
So they are for sure going tomorrow, but we're not allowed to tell them that they are leaving tomorrow.
That's fine.
So do you want to see them now, or how would you like us to do that?
No, I'm just going to order that they be brought back before me if they're not gone. Right? If I'll put it on here. If Pinellas has not transported them, then they're to see me tomorrow.
Okay, perfect.
All right, thank you.
Thank you. So then just give us 2 seconds for your please, because Mr. Montalvo is here.
Okay. Good afternoon. You folks are here for first appearance. At first appearance, I'm going to inform you of the charge or charges pending against you. I will then determine whether or not there's probable cause for the charge. If I do find probable, yes.
Oh, sorry, these are your 2 teams.
I still had some more. I still had
You
some.
have 2.
Simpson bonded.
Simpson bonded, and Montalvo refused, so he needs to be arrested. But he refused.
What about Ashley Gerald?
She bonded also.
Okay. All right, so let me just go ahead and address Jesus Montalvo. We can move on to the 215. All right, so Jesus Adrian Montalvo, 21 MM 363, here for violation of no contact order. I reviewed the probable cause affidavit. I do find probable cause. Bond is set at $25,000. And I have any contact with the alleged victim. Mr. Stewart, was there still a bond on the underlying felony charge? And did you want me to, was there a motion to revoke it at this time?
Judge, if I could just double check, my recollection was that he could not go anywhere anyways. Let me just double check real quick. Because I believe he's in custody on no bond on a VOP.
Oh.
If that's the case.
It's just the allegations of the underlying charge are very concerning.
Well, Judge, just to be on the safe side, then I will ask the court to revoke on 21 CF 249, which is the underlying DV case here. So I can send the court an order.
That's granted. And then just send me an order. Thank you. All right, switching over to the 215 docket. All right, who do I have here?
Here you have Mr. Matthew Valencia and Antonio
Gregoza, you're here for Mr. Hernandez?
Yes, sir.
All right, this is 20 CT 2566. Good afternoon, Mr. Hernandez. We are set for a plea today, is that right?
Yes, sir.
All right, Mr. Gregoza, what are the terms of the plea?
I was 10 days jail concurrent with case number 20 CF 18.
All right.
This reason not heard
State, was it just an adjudication, 10 days jail concurrent with the felony charge?
Yes, sir. And then for cost investigation and adjudication.
Those are the terms, Mr. Stewart?
I don't see cost of investigation. I see a $250 fine, court cost of prosecution, 10 days jail, credit for time served, and an adjudication of guilt.
That sounds good.
All right. Mr. Hernandez, you want to accept those terms?
Yes, sir. I had a question. On the paper, it says third offense. I was wondering, like, it's supposed to be third or second.
Well, let's see, I've got an information that charges it as third or more. So it's being charged as a third.
All right, okay, I'll say.
Okay. All right, please raise your right hand.
Do solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you put your hand down, please? Mr. Stewart?
Sir, can you state your name and your date of birth?
Antonio Hernandez, 8190.
You're charged with one count of driving while license suspended, third or more. Do you understand that's a first-degree misdemeanor punishable by up to 1 year in the county jail?
Yes, sir. Okay, yes.
And do you understand the plea agreement in this case?
He said yes.
And knowing that, how do you wish to plead to this charge? Guilty, not guilty, or no contest?
No contest.
No comment.
Have you read and signed a waiver of rights plea form?
Yes.
Understand all the rights you're waiving when you enter your plea, including your right to have a jury trial in this case.
Yes.
Understand by entering this plea, you're giving up your right to have your attorney file any motions on your behalf or to argue any defenses on your behalf at trial.
Yes.
Do you understand this crime's an enhanceable offense, meaning if you commit it again in the future, you could be charged with a more serious crime, possibly a felony?
Yes.
Do you understand a potential consequence of this plea is that the Department of Highway Safety and Motor Vehicles could take additional action against your privilege to drive?
Yes.
Knowing that, you still wish to go forward with today's plea?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you suffer from any mental illnesses?
No, sir.
Do you understand if you're not a citizen of the United States, this plea and conviction could be used against you in a deportation proceeding?
Yes.
Are you satisfied with the advice and representation of your attorney?
Yes.
Any more questions for him or the court before you go ahead with your pleas?
No.
State will tend to the plea.
I reviewed the probable cause affidavit. I do find that there, well, so here's just kind of a strange thing. Mr. Shore, are these convictions, are they out of state? And the only reason I'm asking is I'm looking at a driving record that doesn't show any prior convictions, although I can see even on the jail record that there was a prior conviction from 2015 in this county. So I've got that discrepancy here.
So let me see.
Understand why, and I'm looking at the driving record, and it's the correct driving record. It's got the defendant's, date of birth, the correct address. At least it's the same as what's on the jail arrest card.
I'm showing May 4th of 2015 and December 4th of 2015 as conviction dates, and I can see if I can find the case numbers.
All right.
And I think
Not that I don't. It's just really strange. That none of that's on the driving record, and it does appear to be. But we've been having issues with the driving record. It's very strange.
15786 CT is one of them.
Okay.
And 152679 CT is another one.
All right. Now then, I do find there's sufficient factual basis and venue have considered the colloquy and find the plea to be freely, knowingly, and voluntarily clear. Therefore, I will accept the plea and impose sentence as follows. For the offense of driving while license suspended, third or subsequent offense, adjudication of guilt, 10 days in the Collier County Jail with credit for all time served, $220 in court costs, $50 public defender application fee, $50 cost of prosecution. Jail sentences to run concurrent with 20 CF 18. There was a fine as well, or was that waived?
I'm sorry, Judge.
Was there a fine, Mr. Stewart, or was that waived?
$250 fine.
A $250 fine. All right, 90 days to pay. Good luck to you, sir. Take care. Thank you, Mr. Rosen. Have a good day. Yeah, I've been seeing this in traffic court too. That we've been getting driving records that are missing entries that we know should be there. I don't know what's going on.
I don't either.
But you know, we're showing you people who have attended traffic school their maximum number of times, and there's no tickets on the driver's license. So I don't know what's happening. All right. So I've got. Is this Mr. Arroyo or Mr. Valencia? All right, and Antonio Joel Arroyo, 21MM135, 21MM136.
Were there any additional things that was not placed on the showcase, if I can add that? This is a global offer, including,
Your Honor, Arroyo was an IJC.
It's not Mr. Arroyo. So this is Mr. Valencia.
Yes.
Matthew Curtis Valencia, 21MM236. Thank you.
Yes, Your Honor, I explain a little bit.
Take your time.
Okay. So, this is, please be arranged and then take the plea.
Okay.
Because they need to resolve this case, because he is, part of the health court. And, the health court is gonna resolve this only today at 3:45, and release tomorrow, and stop the tomorrow at the treatment center.
Okay.
So this has been discussed in the state, and I know it's a little unusual.
No problem. All right. So, Mr. Valencia, you're here on a charge of carrying concealed weapon, and Ms. Brasher, how is your client going to be pleading to this charge? All right. So what are the terms of the plea?
The terms of the plea are adjudicated guilty, time served, and court costs, cost of prosecution, cost of defense.
All right. And Mr. Valencia, do you want to accept those terms?
Yes, sir.
All right. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Put your hand down, please. All right. The state attorney's going to ask you a few questions. Go ahead.
Mr. Valencia, can you state your name and your date of birth? You're charged with one count of carrying a concealed weapon. Do you understand the maximum penalty for that you could face is a year in the county jail?
Yes.
And do you understand the plea agreement in this case, which your attorney just put on the record?
Yes.
Knowing that, how do you wish to plead to this charge? Guilty, not guilty, or no contest?
No contest.
Have you read and signed a waiver of rights plea form? And you understand all the rights on that form you're waiving when you enter your plea, including your right to have a jury trial?
Yes, sir.
You understand by entering this plea, you're giving up your right to have your attorney file any motions on your behalf or to argue any defenses on your behalf at trial?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
And are you currently taking any medication for a mental illness or any medication whatsoever?
He said no.
Oh, I'm sorry. And Mr. Valencia, are you supposed to be taking any medication right now that you're not getting in the jail?
Yes, doctor outside.
Okay, and is the fact that you're not taking medication you would normally take outside of the jail in any way affecting your ability to understand what you're doing here today?
Yeah.
Are you satisfied with the advice and counsel of your attorney?
Yes.
And do you understand if you're not a United States citizen, this plea could be used against you in a deportation proceeding?
Yes.
Okay, state will tend to the plea.
I have reviewed the probable cause affidavit. I do find that there is a sufficient factual basis and venue to consider the colloquy and find the plea to be freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows. For the charge of carrying a concealed weapon, adjudication of guilt, $220 in court costs, $50 for defender fee, $50 cost of prosecution, time served, 90 days to pay, and you said he will be transported to DLC?
The relation of ROR 345 today, and then go to Crossroads.
Crossroads? All right. Sir, good luck. Take care of yourself, okay? All right, good luck to you.
Thank you.
Thank you. All right, so let's switch over to IJC. Does your client need an interpreter? Okay.
I do know that, even though I.
Monthly is not fixed.
Case number 20
There you go. All right, is this Mr. Arroyo?
Yes, sir.
All right, Antonio Joel Arroyo, 21mm135, 21mm136. Good afternoon, sir.
Good afternoon.
Woodley on behalf, and I would like to even add here, I'm not sure why the third one, 20mm134, is not on the docket. This is a global fee offer, if you can add that.
Okay. It was just a moment.
He's going to be withdrawing his previous plea of not guilty, entering a plea of no contest to the following agreed upon terms. In 20mm134, it's going to be adjudication of guilt, 45 days of jail credit for all time served, and he does have 48 home. Cost of investigation in the amount of $429 from White County Sheriff and all court costs. In 20mm135, it's going to be less cost. In 20mm136, adjudication of guilt, 12 months of probation, batter's intervention, no possession of alcohol, cost of investigation to Collier County Sheriff's Office in the amount of $209.50, and all court costs.
Mr. Stewart, do you agree that those were the terms? No, I'm talking to the state attorney, sir.
Yes, those are the terms, Judge.
All right. Mr. Arroyo, now I'm talking to you. Do you want to accept the terms of that plea agreement?
I do accept the violation of the injunction. And I've been having curiosity that the state doesn't, she had talked to the state and she said it's expired and she's not going to come to court.
Antonio, you have two options. You can accept this, or you can go to trial.
But if we go to trial, then it's going to waste time and she's not going to come to court and the state's not going to case.
It's your call. What do you wanna do?
How long is the financial program?
27 weeks.
Well, how many months is that?
20, it said 27 weeks. I'm not great with math. What is that?
By months?
Is it 9?
That's nearly 7 months. Not quite.
It's weekly meetings, and it will be longer if you don't go to each. So what would you like to do?
I said to see. Okay.
Fair enough.
That's pretty clear. All right. All right. Sir, raise your right hand, please.
Do solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yeah.
All right, you put your hand down. Now, sir, there's something I want to be very clear about. You're not required to accept the state's plea offer. You have the right to maintain your innocence and then go to trial. But if you enter into this plea, you're going to have to abide by the terms of the plea agreement. And if you don't, it'll be a violation of probation. You'll find yourself right back in the jail. So are you sure this is what you want to do? Can you get your bond reinstated? No, sir. Okay. All right. Very well. State, please inquire.
All right, sir, state your name and your date of birth, please. You're charged with 1 count of domestic violence battery and 2 counts of violating pretrial release, which is violating a no contact order pursuant to that domestic violence battery case. Do you understand each of those 3 charges are punishable by up to a year in the county jail? I am, but I'm telling you what you are currently charged with and the maximum penalty you're facing. Okay, and you heard the plea agreement in this case that you're going to be entering a plea to 2 of the 3 counts. The state's going to drop 1 of the counts, and 1 of the counts you're going to be sentenced to essentially time served, and the other count to a probationary sentence. Knowing that, how do you wish to plead to 1 count of battery and 1 count of violation of pretrial release? Guilty, not guilty, or no contest?
No contest.
Have you read and signed a waiver of rights plea form?
Yes, I did.
Do you understand all the rights on there you're waiving when you enter your plea, including your right to have a jury trial?
Hold on, Mr. Stewart. What did you say before that, sir?
I haven't seen it.
Okay, sorry, Mr. Stewart, go ahead. Do you understand those rights?
Yes, sir.
Go ahead. You understand you're waiving your right to a jury trial?
Yes.
You understand you're waiving your right to have your attorney file any motions on your behalf or to argue any defenses on your behalf at trial, such as self-defense?
Yeah.
You understand battery is an enhanceable offense, meaning if you commit it again in the future, you could be charged with a felony.
Yes.
You suffer from any mental illnesses?
No.
Are you currently under the influence of any drugs or alcohol?
Yeah. No.
Do you understand if you're not a citizen of the United States, these pleas and convictions could be used against you in a deportation proceeding?
Yeah.
Are you satisfied with the advice and representation of your attorney?
Not really, but it is what it is.
Is there anything she did not do in your case that you wanted her to do?
If I just think they take whatever it's gonna hold on, I'm in jail.
All right. I hold on, Mr. Stewart. I'm not comfortable accepting the plea at this time. There's been hesitation indicated some of the answers by Mr. Arroyo. I'm just not comfortable accepting this time. Ms. Woodley, I'll give you a chance to talk to Mr. Arroyo. And then, if you want to reset this for tomorrow, just let my JA know. I understand. Tomorrow or Friday, whichever it is. Yep. I'm sorry. I'm not. There was hesitation. There was disagreement. There was hesitation to even accept the plea to begin with because he indicated he would otherwise plead not guilty. I'm not comfortable accepting the plea at this time.
it out, my mom's waiting for me, she's there.
NJC, the judge made his decision, you can remove.
Sorry.
5:40 on this exam appointment.
I know.
5:40.
I know. All right, thank you, Mr. Stewart.
Okay, Judge, have a good day.
Have a good one.